Welcome to Canadian Justice. I'm Christine Van Gyn. It's a new year, and I wanted to spend some time talking to the leaders of my favorite legal charities and organizations about what they did in 2022 and what they're looking forward to in 2023. Today's guest is the executive director of the Christian Legal Fellowship, Derek Ross. The CLF is a legal charity that seeks to advance the public good by articulating principles that are consistent with and illuminated by the Christian faith through court interventions and public consultations. I am really excited for this conversation and to talk about what the CLF has achieved in the last year and what they look forward to in the coming year. Derek, thank you so much for joining us today to talk about your work. Let's start off. Why don't you tell me a little bit about yourself and your background and how you got involved in Christian Legal Fellowship?
Sure. Well, thanks so much for inviting me today, Christine, and Happy New Year to you and to all of your viewers.
Yes, Happy New
Um,
Year.
Thank you. So, by way of background, I am a constitutional lawyer. But even before I became a lawyer, even before I went to law school, I was always interested in religious freedom as a person of faith. I was always interested in how the law interacted with faith communities and also how religion interacted with the law. So when I started law school, I was really excited to learn that there was this community at my law school on campus called Christian Legal Fellowship, a group of students that were also interested in those issues, but more importantly, also wanting to examine how our faith can inform and connect to our work and really enhance our work as lawyers that are really called to serve the public, to serve our clients and our communities. And so connecting those dots between faith and law was something that really drew me to the work of Christian Legal Fellowship. I practiced in private practice for a number of years before joining the organization as executive director in 2015.
So, can you expand a little bit on what the goal is of the CLF? What is the mission of your organization?
Sure. Yeah. So at its heart, Christian Legal Fellowship exists really for what that group of students existed for at law school, which is to provide a space for people to come together and explore the intersection of their faith, their core belief commitments, with their work as people that are called to uphold the rule of law, to advance justice, to serve their clients, and to try to bring reconciliation and restoration to disputes. And so, those are things that some people might think that law and religion don't mix, but there are a lot of principles from our faith traditions, not just Christianity, but other faith traditions as well, that are very much consistent with the goals of our legal system, which is to advance justice. And
Hmm.
so CLF does that both at an individual level by working with law students and lawyers and helping them practice law in a way that is consistent with their core ethical commitments, but also in collectively as a group of lawyers and law students advocating for justice and participating in public policy dialogue and legislative consultations and in court interventions, where we as a group of lawyers come together and work with other groups and contribute our voice to this larger conversation of what does justice require in our free and democratic society.
Such a valuable perspective. Now, the CLF also does what's known as interventions, which is where they appear in the court but not as a party. So, can you explain for our viewers what interventions mean? What's their role in the judicial system? And what role Christian Legal Fellowship plays when they decide to take on an intervention?
Yeah, absolutely, Christine. So the traditional court case really involves two parties, typically, a plaintiff and a defendant. And largely, in most cases, the court is asked to resolve a dispute between those two parties. Sometimes there's more parties, but it's really often a private dispute. And the outcome typically impacts those parties that are part of the dispute. But
Mhm.
in some cases, especially in constitutional cases where the court is being asked to interpret the Charter of Rights and Freedoms or engage in a consideration of issues that have broad implications. The court recognizes that its decision might impact more than just the parties in front of it and might have wide, far-reaching effects for
Mhm.
Canadian society as a whole.
Yeah,
And so what
and that's when an intervener comes in and they provide some assistance to the court by showing these alternative perspectives. Now we've got to go to break, but I want to dig into that further when we're back.
absolutely.
Welcome back to Canadian Justice. I'm talking to my friend Derek Ross, the Executive Director of Christian Legal Fellowship, about what his organization did in 2022 and what they're looking forward to in the new year. So, in the last segment, Derek, we were talking about the role of interveners in the court. This is a friend of the court who comes in when the implications of a case are beyond just the two parties to the dispute. And CLF has done a number of interventions, including a really, really important one in Quebec related to the religious symbols law in that province. Can you tell us a little bit about that law, what it does, its impact on the religious and faith communities in Quebec, and the position of the CLF?
Absolutely. So viewers might be familiar with Bill 21. That's the controversial piece of legislation in Quebec, which purports to advance neutrality, state neutrality, the idea that the government should not take sides on religious questions, which is in itself not a controversial principle. That's something that the Supreme Court has said is, in fact, a constitutional principle that the state should remain neutral. But how the bill advances it is quite controversial because what it's done is it's prohibited a number of categories of workers in the public sector from wearing religious symbols at work. And what that has done is effectively excluded a large number of faith members of faith communities from working in the public sector as teachers, as lawyers who work for the government. They're forced to either disavow their openly religious identity or to abstain from participating in these public institutions as a public employee. And so we're really concerned about that because it takes the position that one's faith identity is something that is inherently problematic, that needs to be suppressed or hidden or neutralized, when in fact the richness of our commitment to diversity is really something that's enhanced by allowing people of all faith communities, including those who do not have religious identity, to all participate in the public square. That's what we believe neutrality requires, is not to be opposed to religion, but equally accommodating of all religious identities and non-religious identities. But Bill 21 does the opposite. It basically prioritizes those who are not religious or those who are willing to appear to be non-religious over those whose faith commitments compel them to wear a religious symbol as an observation of their sincere religious commitments. So the Quebec government, in invoking this bill, relied on the notwithstanding clause. That's a provision of the charter that allows a law to operate even if it limits certain core constitutional protections, such as religious freedom and equality. And so the Quebec Superior Court, who first heard this dispute, largely upheld the law on the basis that the notwithstanding clause immunized it from being struck down. However, the lower court did take issue and express concern with a number of elements of the legislation, and also struck down aspects of it which limited certain charter rights which are not subject to the notwithstanding clause, protections for minority language education rights, for example, and democratic rights. So because this was something of a mixed result, both sides appealed that decision to the Quebec Court of Appeal, where Christian Legal Fellowship intervened along with a number of other groups. And the Quebec Court of Appeal heard that appeal in November. We're expecting a decision sometime later this year.
And depending on the outcome, what do you think the chances are that this will be appealed again to the Supreme Court of Canada?
Yeah, I think either way, this is a case that is likely to make its way to the Supreme Court of Canada. I can only speculate, of course, but this is an issue that engages really national interests, right? It asks this question of, can a provincial government exclude people from participating in its public institutions solely on the basis of their openly religious identity. That's a question that impacts not just religious minorities in Quebec, but religious minorities across the country. And that's one of the reasons that Christian Legal Fellowship wanted to intervene, to argue that a true conception of state neutrality is one that accommodates everyone and doesn't prefer one group over another.
Fascinating arguments, and we're going to be watching that case closely at Canadian Justice. We've got to go to commercial break now, but when we come back, I want to talk about one of the other controversial legal topics that's really hot right now, and that is medical assistance in dying and what Christian Legal Fellowship's perspective is on that issue. We will be right back. Welcome back to Canadian Justice, where I'm chatting with Derek Ross, the Executive Director of Christian Legal Fellowship, about what 2022 was like for his organization and what to expect in 2023. Now, Derek, we're going to talk about a very uncontroversial topic, very benign, and that's medical assistance in dying. Obviously, a huge issue right now in Canada that's gotten, in fact, international attention because of the expansion of MAID, medical assistance in dying, and now pause of MAID for people with mental illness. Now, I know that the CLF has taken a position on the issue. What can you tell me about the position that you've taken, and have you responded to the current pause?
Sure. Yeah. And just to take a step back, maybe to explain the terminology to those that might not be super familiar. When we're talking about medical assistance in dying, what we're talking about is the act of ending a person's life at their request through the administration of a lethal substance. So it's not palliative care. It's not medical assistance in the way that some might traditionally understand it in terms of providing medicine and care through the natural dying process. It is the act of causing death
So
itself.
important to make that distinction because the name medical assistance in dying might sound more neutral than perhaps it is.
Right. And I think that the terminology has caused confusion in the past. So just wanted to clarify that. And it has only been legal in Canada since 2016. And when it was first introduced, it was introduced on the premise that it was an exceptional practice designed to be limited and subject to strict scrutiny. And one of the limits that was imposed initially was that a person's death, their natural death, needed to be reasonably foreseeable in order for them to be eligible for MAID. In other words, MAID was designed to hasten an already foreseeable death. And in that way, it was seen as not causing death so much as hastening it. At least that was how it was conceived by those supporting it. But it was that became controversial. And so as a result of another lower court decision in 2021, the federal government passed another law called Bill C-7, which expanded MAID and removed that reasonably foreseeable death requirement so that it became available for those whose death was not foreseeable, to patients who were not dying for conditions that were not life-threatening. And that was controversial and remains controversial because it effectively treats disability-related suffering as something that merits state-sponsored termination effectively, with the consent of the patient, of course, and meeting other criteria. And so a number of disability organizations and groups like CLF are very concerned about this notion that death will be offered and provided in our healthcare system as a solution to a non-life-threatening disability-related suffering, but only on the basis of disability or illness. It's only disability-related or illness-related suffering that makes one eligible for MAID. And that has raised a lot of concerns, not just amongst the disability community, but also amongst human rights experts. The United Nations, a number of their human rights experts have raised concerns that MAID is being offered basically as a therapeutic solution to disability-related suffering, particularly in a context where disability supports are not always available or accessible. And that's what's raised a lot of concerns, is that we've offered death as a solution where we haven't always offered life and meaningful medical assistance in living to individuals with disabilities. And that's not simply hearsay. The federal government's own annual reports have confirmed each year that in total now hundreds of cases of MAID deaths have taken place where the individual needed but did not have access to disability supports or palliative care. And that's hugely, hugely troubling. And then we now are in this current context where, when Bill C-7 was passed, initially the federal government did not include mental illness in its definition of the types of illness and disability that would be eligible for MAID. But they said that would change. They introduced what's called a sunset clause, saying that MAID would be available.
And it was
in
supposed to
cases.
be available now in 2023, or very soon in the new year. But they did announce a pause on that. Now we've got to take our own pause and go to commercial break. But when we come back, I want to discuss CLF's reaction to that pause. Welcome back to Canadian Justice, where we're discussing the work of the Christian Legal Fellowship with Executive Director Derek Ross. Now, Derek, in the last segment, we were just wrapping up our conversation about how medical assistance in dying or assisted suicide was going to be expanded in 2023 to be available to people who wanted to end their life because of mental illness. But the federal government put a pause on that expansion. So does CLF have a reaction to the expansion itself and then to the pause?
For sure. Well, first of all, we are grateful that the government has been willing to take a pause and hear the concerns that are being raised by medical professionals, by disability organizations, by groups such as ours, and recognizing that Canada is not ready for this yet. But we are concerned that simply postponing this or rescheduling the introduction of MAID for mental illness doesn't get to the underlying concerns and the underlying issues. And the fact remains that in the same way that disability supports aren't available, mental health supports are not available or widely accessible in our country. There are long waiting lists. And so again, we're concerned that we would be effectively prioritizing death over life in terms of what we're offering to treat mental illness in Canada. And we've already seen, we know from the federal government's annual reports that people are already seeking MAID because they perceive that they are a burden on their loved ones, or because of their experiencing isolation or loneliness. That has been a factor in thousands of MAID cases to date, according to the federal government's reports. And so we need to look at those things and address those things. And we're really concerned about expanding euthanasia for mental illness in this context. So CLF is urging the government not just to postpone or reschedule this, but to, instead of advancing this, to focus its efforts on providing medical assistance in living for those with mental health challenges.
So important to have compassion for the people who are suffering, and compassion that allows them to live a life that they would want to live if they had support. Now, I want to move on to what types of cases you are looking forward to in the new year, because it is a new year. Is there anything new on your agenda that you're looking forward to in 2023?
For sure. Well, we have a lot going on. And again, we're going to be busy with all these issues that we've just spoken about, and waiting for some of the decisions from last year. We're going to be working on all of these things. One thing that we're really excited about, though, is some of the work that we do with law students and law schools, and with academic engagement. So Christian Legal Fellowship has student chapters at 16 law schools across the country. And each year we also do an annual academic symposium on religion, law, and human rights. And this year's symposium is going to be focused on the 75th anniversary of the Universal Declaration of Human Rights. That's a very significant international human rights document that Canada actually played a lead role in drafting, and also signed and has committed itself to uphold. And so at this 75th anniversary, we think it's really important for us to look back and ask, why it was necessary to introduce the Universal Declaration of Human Rights in the first place. It was adopted in the immediate aftermath of the Holocaust and of all these atrocities in World War II, which were sometimes carried out according to the letter of the law in place at that time. And so, what the UDHR reminds us is that our human rights are not just subject to the pen of the government of the day, that our human rights are something more core, that in the words of the Declaration, they are inherent, they are inalienable, they are our birthright as human beings. And so because they aren't given to us by the state, they can't be taken away from us by the state. And so we want to spend some time and explore, what does that mean for us to have inherent dignity and inalienable human rights, and how can that be protected in practical terms?
Such a fascinating topic, and I'd love to attend that as well. Derek, Happy New Year. Thank you so much for coming on and telling us all about the very important work that you do.
Thanks so much for inviting me, Christine. Thank you.
We've heard today about Christian Legal Fellowship and the work that they do both in the courts and in public education. How do you think organizations like the CLF can contribute to the development of the law and the legal culture, as well as public discourse? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.